Good evening, everyone. Welcome back to our channel for continuation of our criminal law series. Those who are attending today for the first time, please ensure to go back to our channel and watch the previous discussions. In today's live session, we will explore the intricacies of drafting and arguing a private criminal complaint before a magistrate. Private criminal complaints empower individuals to seek legal recourse against alleged offenders. But navigating the legal process requires meticulous preparation and strategic advocacy. In this session, we will delve into the essential steps of drafting a comprehensive complaint, including gathering evidence, framing charges, and adhering to procedural requirements. Moreover, we will also provide practical guidance on presenting your case effectively before the magistrate, including crafting persuasive arguments, anticipating counterarguments, and navigating cross examination. Whether you are a victim seeking justice or a legal professional representing a client, this session will equip you with the knowledge and skills to navigate private criminal complaints with confidence. Don't miss out on this opportunity to empower yourself with expert insights into drafting and arguing a private criminal complaint before a magistrate. I welcome back our speaker for the session, Beeta Bajwa, an accomplished criminal lawyer with an impressive 14 years of experience specializing in criminal trials. Welcome and over to you, ma'am.
Thank you so much, Swatilekha. Good evening, everyone. So, your today's topic is on how to draft a criminal complaint before the magistrate. Now, we will be covering up that what are the sections under which a criminal complaint is to be filed before the magistrate, what exactly is the procedure for a criminal complaint, and how it is to be drafted, what is the procedures to be followed, and what exactly are the intricacies which are to be noted and which are to be kept in mind while drafting a police complaint. Now, first and foremost, a criminal complaint to a magistrate is filed under section 200 of the CRPC. That is a private complaint. We have covered up in our first session about a police complaint to the police officer. Now, whenever there are cognizable offenses made out, you will directly send a complaint to the police complaint to the police officer, and you will follow the ratio laid down, the guidelines laid down by the Honorable Supreme Court in Lalita Kumari's case, wherein the Supreme Court has clearly said that when cognizable offenses are made out, the police has to register an FIR. So once you send a police complaint, the police, if cognizable prima facie cognizable offenses are made out, the police has to register an FIR. Now, what do you do in such a case if they fail to register an FIR? What is the remedy under law that you have, what you can take recourse to? Now, the remedy under law is under section 156, subsection 3 of CRPC. That's right. In the event, if the police, you send a police complaint and you are an aggrieved person and the police refuses to register an FIR, they don't register an FIR, they don't conduct any investigation. You follow up with the officer, then also they don't register any FIR. After that, what do? You will send the same complaint to their higher authorities, that is the ACP or the DCP and the CP, and you will inform them that you have already sent the police complaint to the police station, but the senior inspector is not taking any action on your complaint. So direct your subordinate to investigate the matter and register an FIR. Now, in the event when if you have even sent it to the higher authorities and then also nothing happens, what do you do in such a case? You will go before the magistrate and you will file a private complaint under section 200 of CRPC, wherein you will invoke the powers of the magistrate or under section 156 subsection 3. Now, what exactly are the powers under 156 subsection 3? As per section 156 subsection 3, the magistrate has the power to direct the police to register an FIR if cognizable offenses are made out. So that's exactly what you're going to do. Once you file a private complaint before the magistrate, you have to satisfy the magistrate that how you have followed the ratio, you have followed the guidelines laid down by Lalita Kumari, how prima facie cognizable offense is being made out, But then also the police is not registering your FIR, and that is why you were left with no other alternative to come before the magistrate and invoke its powers under 156(3). Now there is a particular procedure for proceedings under 156(3). There is a procedure when you file a private complaint. Once you file a private complaint, how you draft a private complaint, who is to be made a party when you file a private complaint, all these things are to be noted. Once you file a criminal complaint, if it is you are seeking orders under 156(3), you will make the police station the a party, the respondent in the complaint. So your complainant would be the complainant who is filing the complaint, who had filed the complaint, and the respondent will be the police station. Along with that, whoever accused against whom you want the complaint to be proceeded, they too have to be made an accused. They have to be made a party in the complaint. Once you file the complaint, is you will also have to mention the sections, the offenses for which sorry, you want them to be prosecuted. Now, once you write all the sections in the title, you will start by giving a brief background about who the complainant is, what is the complainant's dispute with the accused, what was the transaction with the accused, and what was the offense committed by the accused. Simultaneously, in the body, you have to, if you are levied, whatever sections you have levied, you have to satisfy and give an explanation how those sections are applicable and how the offenses under those sections have been committed by those accused, and what was the act committed by the accused that this section would be applicable. Now, time and again, I have explained, for example, if I am saying that, I'm saying forgery, 467. So, what was the document which was forged? What was the way that the document was forged? What is the forgery which has been conducted? And how the accused has conducted the forgery? All this has to be explained. Now, in the event if this forgery or the cheating has been committed by with more than one person in connivance, in a conspiracy, as a conspiracy with each other, then you have to give a specific role to each and every accused. Always remember attributing specific roles to each and every accused, because if you don't do that, then no role would be attributed to that accused. One, getting an order of an FIR against an accused will be difficult. Second, it will become a good case for that accused to go before the appellate court, before the higher court, for quashing of that complaint against him. Once you write that, you, in the end of the complaint, at the body of the complaint, you have to satisfy the court that how you have followed the guidelines of Lalita Kumari. You had sent a police complaint to the senior PI, but the senior PI apparently has not done anything, not conducted any investigation, not done anything, and that is the reason you are constrained to come before the magistrate, and you are requesting the magistrate to invoke his powers under 156(3). Your prayer clause for 156(3) would be wherein that this honorable court be pleased to direct the so and so police station to investigate the offenses under the accused so and so, and in the event cognizable offenses are made out, register an FIR against that accused. That would be your prayer clause for 156(3). That's exactly what 156(3) is, wherein the magistrate directs the police that this complaint has come to you. Prima facie, I am satisfied that there is an offense made out. Investigate this offense, and if a cognizable offense is made out, register an FIR immediately. Now, you would notice this in a lot of cases that as soon as a 156(3) order is passed by the magistrate, immediately an FIR is registered. Now, you may note this in a lot of times that in the FIR, a name instead of FIR number, you would notice it is written as MECR number. Now, what exactly do you mean by MECR? MECR means Magistrate Inquiry Crime Report. So once you see a MECR number basically means that this FIR has been registered at the instance of the magistrate on the orders under section 156(3). So be careful whenever an FIR comes to you. The first thing you need to notice is whether this FIR was registered at the instance of the magistrate order. One. This is what 156(3) says as. Now the Honorable Supreme Court in the judgment of Priyanka Srivastav has also held that whenever a prayer is made for 156(3), complaint is filed wherein orders under 156(3) are being sought from the court, and affidavit in support of the complaint along with the criminal complaint is mandatory. Now, what is that affidavit in support as per Priyanka Srivastav's judgment? Affidavit in support is basically the affidavit of the complainant where the complainant repeats and reiterates the contents of the complaint and says that whatever stated in the complaint has been stated is true and correct and as per my knowledge. Now, in the event if you don't affix the affidavit in support of the complainant when you're seeking orders under 156(3), remember this that this will be a technical lacuna, and as per the ratio laid down by the Honorable Supreme Court in Priyanka Srivastav's judgment, that complaint can be dismissed by the magistrate because there is a technical lacuna. You have not followed the Supreme Court. So always remember this and make it a point that when you are seeking orders under 156(3), always affix an affidavit in support. Now, this is what we are talking about 156(3). What happens sometimes you would also notice that clients come to you and they say that no, so I don't want an FIR to be registered. I don't want to involve a police machinery in this, but I want to prosecute the other person. Then again, what you do is you file a complaint under section 200, wherein you will proceed with the complaint as a private complaint. Your prayer clause would be directly seeking prayers, wherein you will be directly asking the magistrate to issue process under section 204 of CRPC against the accused. Once you do this, once you ask that, you are filing a private complaint and you are seeking process orders against the accused. Remember this. So this is a private complaint. Now there is a procedure of a private complaint. Now when it comes to complaint, when you're seeking orders under 156(3), once you file the criminal complaint, you file the affidavit in support, it is directly placed for arguments before the magistrate, wherein you argue before the magistrate and you satisfy the magistrate that prima facie case is made out, so please give me orders under 156(3). Now, this is totally the discretionary power of the magistrate. He may feel that he wants to give the orders under 156(3). He may give you the orders. If he feels that no, a 156(3) is not required and let it proceed as a private complaint, magistrate may also pass an order saying that let the prayer for 156(3) is rejected, complaint to proceed under section 200. Now we come down to what do you mean by this? This means that now the complaint is going to proceed as a private complaint and not as a police complaint. So once the magistrate passes an order that complaint to proceed under 200, the matter automatically gets placed for the stage of verification of the complainant. What exactly is the verification of the complainant? Verification is that the complainant goes into the witness box and in brief, he will depose about the whole case. In brief would be your criminal complaint may run into pages, say somewhere around 30, 35, 50 pages. But in the verification statement, you have to sum up everything in 2 to 3 pages. He has to give in brief that this is, I am the complainant, these are the accused, this is how my transaction was with them, this is what the offenses have been conducted by them, and this is how the sections are applicable, this is the offenses committed by them, and therefore this is the process needs to be issued against them. Once the verification of the complainant is completed, in the event if you want to examine any other witness, you can do that. You will examine any other witness as your witnesses. Their verification statement can be recorded, and then the matter is placed for arguments on process. Now, what do you mean by process? Issuing summons from the court is called as process. So when the court issues a summons, if you open the CRPC, at the end of the CRPC, you will find all the formats of a warrant, of a process, of a summons. Those summonses on notice through the court to the accused to come before the court that a case has been filed against you. You have to appear before the magistrate on so and so date and file your wakalatnama, file your bail application, and undergo the trial. This is called as process. So the court issues summons against the accused. The summons may either be taken by hand, or the court, in most of the cases, the court directly issues the summons and they are delivered to the accused. Once the summons is served to the accused, a summons report is to be filed by the police before the court saying that whether the summons was served or not to him. Now, if you get a positive report which says that the summons have been served to the accused, what do you do in such a case? In such a case, if the summons have been served to the accused, you will file an application for bailable warrant against the accused. Now, always remember, this can be only taken to recourse if you get a positive report that the summons is served. But if you get a negative report which says that the summons was not served to the accused, you have to reissue the summons and get the summons served. Also remember, as per criminal law, summons cannot be served on a servant, neither can it be served on a woman. So if a summons is, say, I have issued to Mr. XYZ, he is not at home, but the summons is served to his wife or the servant, then that would not be complete service. That cannot be taken that the summons have been served. It has to be served either to a male member or it has to be served to the accused himself. Now, once the summons is not served, you will file an application for reissue. But if the summons are served, you get a bailable warrant. Even after bailable warrant, your bailable warrant is issued and it is executed. Then also, if the accused doesn't come, then you will make an application for NBW, which is called as a non-bailable warrant. Once the non-bailable warrant is issued, and if thereafter, then also the accused doesn't come, or if after service of the NBW, he's produced before the court, he takes bail, cancels the warrant, and he goes, or he comes behind, he who can anytime cancel the warrant before the court before execution. Now, what is the procedure? You can go before the court, take the matter on board of the honorable court, file an application that the warrant was issued by this honorable court. The warrant was issued but not executed, and therefore it can be cancelled, and the magistrate cancels the warrant. Because the warrant cannot, once it is executed, if the accused is arrested on that warrant, then the warrant cannot be cancelled, then he has to take bail. But if there is only the warrant issued, but the accused was never arrested on that warrant nor produced before the court, then that warrant can be anytime cancelled by the accused. So your application for cancellation would be that the warrant was issued but not executed. Now, once that is done, after cancellation of the NBW, if he again fails to come, then what do you do in such a case? Then you have the powers under section 82 of CRPC. You can issue a proclamation against the accused. You issue a proclamation saying that this guy this accused is an accused in the matter, and he be declared as a proclaimed offender because he has ran off. After a proclamation is issued and he's been declared as a proclaimed offender, then also if the accused doesn't come before the court, then you will file an application for attachment of his properties, and whatever properties which are owned by the accused, the magistrate has the right to attach the properties. But many a times you would see that the accused nowadays have become very smart and they don't keep any properties in their name because they know, everybody knows the law nowadays, that the magistrate is going to attach the property. So what do you do in such a case? If you get any knowledge about the property, well and good. If you don't, then you get a paper publication, that is a proclamation issued against him. And then also, if you are unable to find the accused, you have no other option than putting the file in a dormant file, that is DF. A dormant file is you make an application to the magistrate saying that I do not know any, this is the last known and correct address of the accused to me. He's absconding. I don't have any, I have tried to take out any knowledge about the properties owned by him, but I could not procure or find any properties owned by him. And then this file may be kept in dormant file. Now, dormant file is, it is kept as a DF, it is kept as a dormant file, and whenever that accused appears, all these cases against him will be reopened. The most classic example of this, the gangster Chota Rajan, if you remember, that when Rajan was not arrested, he had a number and multiple number of FIRs registered against him, and he was absconding. Once he was absconding, and once he was arrested, all these files were reopened against him. Now, these files have been pending not only from this 2 or 3 years. These have been pending from many years, many years against them. So when such a thing happens, what do you do is, so that is why it was kept in dormant file, and now they all were reopened, and that is why if you see that all the pending cases are going against him. So this is what happens in a way if it goes under the dormant file. But what is the procedure if it doesn't go into a dormant file? What is it if it is, you know being proceeded naturally? So you get the verification, you argue for process, you get the summons issued, the accused comes, and once he appears before the court, he has to file an application for bail. Once he files an application for bail, after filing the application for bail, the plea of the accused is recorded. Now you have two types of trials. One we call as a warrant trial, the other we call as a summons trial. Summons trial are offences which are less than 2 years are called as summons trial. Offences which are punishable for more than 2 years are called as warrant trials. So you have something which we call as key. In the event, if it's a summons trial, you will have a plea recorded. But if it is a if it is not if it is a warrant trial, you have something called as charges, which is framed against the accused. So this is what happens in a warrant trial. Now, if it is a summons trial, and during that time there will be only plea recorded against him. After the plea is recorded, the matter is then placed for chief examination of the complainant. The complainant appears, his chief is recorded by the court. It can be by the court, it can be oral, it can even a written chief examination can be filed by you. Once you do that, okay, once that is filed, after the chief examination, the other side will cross examine the complainant. After the cross examination is complete, any other witnesses are to be examined. Those witnesses would be examined, and uh, after the completion of these witnesses, the prosecution closes its evidence. After its evidence is closed, after the evidence is closed, then it is kept for the statement of the accused under section 313. Once that is done, after it is kept for evidence of the evidence of the defense. Once the evidence of the defense is led, then it is kept for final arguments and judgment. Now, this is what is a procedure of a private complaint. That is how a private complaint proceeds. It's very simple. Similarly, when if it's a warrant trial, you have something which we call as an evidence before charge. Now, what exactly do you mean by evidence before charge? If it's a warrant trial case, once the accused appears, okay, once the accused appears, after that, he his plea won't be recorded. He will only take the bail. After taking the bail, the matter is kept for the stage of EBC, that is what we call as evidence before charge. Once evidence before charge is wherein the complainant goes into the witness box, and the complainant goes into the witness box. After that, his chief examination is recorded, and the defense will reserve its cross examination. Once that is done, okay, reserve, then the matter is going to be argued for charge. Now, what do you mean by charge? Charges wherein all the charges against the accused are read to him and told to him that this is what is the offenses against you, and whether you plead guilty or you plead not guilty. If the accused says that I plead not guilty, and if the court is prima facie satisfied that yes, there is an offense made out, yes, there needs to be yes, an offense is made out, and yes, charges needs to be framed against the accused, they will frame the charges, and then the matter, if any further chief examination is to be led, it will be kept for that. Otherwise, it is kept for cross examination by the defense, and the procedure then is exactly the same. All the witnesses will be put into the witness box, their cross examination would be conducted, it will be kept for the statement of the accused under section 313. Now, what exactly is a statement of accused under 313? Circumstances against the accused are put to the accused in his statement under section 313. What are the circumstances? Circumstances are whatever in the chief examination the witnesses depose against the accused, they are to be put to the accused in his statement. For example, PW1 Mr. So and so has said in his so and so, PW2 Mr. So and so in the chief examination has so would is it correct, do you would, is it true or it is false? And at the end, you will have the uh, at the end you will have something which we call as the defense. The court is going to ask that what exactly is to be, why they are deposing against you. Okay, so all these things are to be noted during the trial. Swatilekha, can we share the draft?
Sure. Yes, ma'am.
Now, if you go through this draft, you can make out that this is how the title will go as this is the complainant, this is the accused. As I said, that these are the accused. Whatever this will be your title, that what are the complaint under section so and so, what do you want to file? Okay. After that, you also have, if you see, may it please your worship, then you will mention who is the complainant, how is he authorized. If it's a company, he has to be authorized to file this complaint by the company resolution. Then you will, whether he is a competent person to depose about the same or not. All these things have to be mentioned. All the documents which are in your favor, okay, are to be mentioned. All the documents which you are relying upon are to be annexed as exhibit A. Now, why do we put A, B, and C? The reason being because the exhibits are given numbers by the court, so we always put alphabets, because so that it doesn't. Once the document stands proved before the court, then only it can be numbered. Then you go down. You will have to, if it's a company, you will have to mention registered office where it is. Then you will also description about the post of the accused, how the persons are in charge of the company. Offenses to be disclosed have been committed, whether they become complete knowledge, consent, connivance. You will put facts of the case along with the, if there has been any correspondence between the parties and in exchange of any legal notices, and how this court has a jurisdiction, whether the cause of action has arisen, under the jurisdiction of so territorial jurisdiction of so and so police station, and that is why this police station has the jurisdiction to take cognizance, and therefore process needs to be issued. Then you also have to mention that as per 1 month section, that how what these offenses are committed, what is the punishment under them. Once you give a description, let's go down to the end to the prayer clause. You would also mention if you are seeking 156.3 that you have followed the guidelines under Lalita Kumari. Please to exercise its powers under 156.3, direct the so and so police to investigate the said offences against the accused, and in the event cognizable offences are made out, an FIR be registered against the accused for commission of offences punishable under section so and so. Okay. Any other? Similar way, for your private complaint, your prayer clause would be directly to issue process. Let's go and see the prayer clause at the end. You have a list of documents and a list of witnesses also to be issued. But this is what is in a 200. Directly, if you're asking for process, that this honorable court be pleased to issue process against so and so, produced before the honorable court and tried in accordance with law. This is when you want a direct process to be issued. So there you are asking that direct the police to investigate and register an FIR if you wanted 156.3. Herein, it is directly issue process and prosecute them. This is the basic difference between a private complaint in a 156.3 and 200. Over to you, Swati.
Thank you, ma'am. So, ma'am, I would like to ask some questions which our students have asked, during our sessions. How to file the complaint before the magistrate?
Just as I showed it to you.
All
This is
right.
the format it has to be filed into. You will put the title, you
Same
will put
format.
all the documents, you have a list of witnesses. This is how the complaint is to be filed.
Right. So, what is the difference between section 202 and 156.3 basically?
Now, 202, if you see, that is also magistrate inquiry. 156.3 is wherein the magistrate exercises powers and directs the police to investigate and register the FIR. In 202, it only directs the police to conduct a preliminary inquiry, not an investigation, not a full-fledged investigation. Only a preliminary inquiry where they call the accused, record the statements, and file their report whether prima facie a case is made out. That is called as 202 inquiry, not a proper investigation.
So, is it a
That is the
mandatory
basic.
provision?
And there was a lot of debate about that whether it is a mandatory provision or not, because 202 is basically taken recourse to when the accused is residing outside the territorial jurisdiction of that court. So during that time the court has to postpone the issue process and conduct the inquiry. This is how 202 comes into play. But there was a judgment of the Honorable Bombay High Court of Bansilal Kabra, which had clearly said that it is a directory provision, not a mandatory provision. But the full bench has recently, that and the matter was placed before the larger bench, and the larger bench has clearly decided that this is a mandatory provision. So whenever the accused is residing outside the territorial jurisdiction of the court, they have to postpone the issue of process under process and conduct a preliminary inquiry under 202.
Got it. Got it, ma'am. So, thank you, Beeta ma'am, for the insightful session. I hope everyone has enjoyed this webinar. We will meet again this week on Sunday at sharp 11:30 a.m. and continue this
Yes.
series with more practically useful topics and information. Also, please ensure to comment and ask questions and queries at the end of the session. Till then, take care and have a good day.
Thank you. Bye. See you.